we are decoding the Hindu editorial titled The Infirmities in the SIR of Electoral Rolls. This editorial, written by P.D.T. Achary, former Secretary General of the Lok Sabha, critically examines the Election Commission of India's recent decision to conduct a special intensive revision, SIR, or electoral rolls in 12 states and union territories including Milnad, Kerala, West Bengal, UD and India just months before elections. The move has sparked protests from several state governments and has been challenged in the Supreme Court. Earlier this year, a similar SIR was conducted in Bihar before the assembly election, raising legal and constitutional questions. The opposition argued that holding such a large-scale revision immediately after a summary revision in 2024 was unconstitutional and rushed. The ECI justified its action by citing demographic changes such as migration, urbanization, and deaths since the last SIR held in 2002 to 2003. However, the key issue lies in the timing. Conducting an intensive revision which involves door-to-door enumeration, verification, and appeals just before elections is questionable. Between 2003 and 2024, multiple general and state elections were held without such a revision. So why now? Under Section 21 of the Representation of the People Act 1950, the ECI can conduct revisions summary or intensive. Summary revisions are quick updates before elections, while intensive revisions, as per Rule 25 of the Registration of Electors Rules, 1960, are comprehensive and time-consuming. Hence, such intense revisions are meant for non-election years. Doing one just before elections goes against the spirit of the law. Another major issue concerns citizenship verification. The ECI asked applicants to produce documents proving citizenship but excluded Aadhaar, claiming it's not proof of citizenship. However, the Supreme Court intervened, allowing Aadhaar as a valid identity document. This raises a crucial constitutional question: does the ECI have the power to determine citizenship documents? The answer is no. Under Articles 5 to 11 and the Citizenship Act 1955, citizenship matters fall under the Ministry of Home Affairs, not the ECI. The Commission can only verify documents notified by the government. It cannot create its own list. The editorial also cites the 1995 Supreme Court case of Lal Babu Hussain, which held that once a name is entered in the voters' list, it's presumed valid unless proven otherwise. Arbitrary deletions would violate Article 14, Equality before law, and Article 21, Right to fair procedure. In short, the editorial warns that while voter roll accuracy is vital, it must not come at the cost of legality, fairness, and constitutional propriety. That's all for today's Decode IAS editorial analysis. Remember, for UPSC, always link such issues to Representation of the People Act, citizenship laws, and constitutional principles of fairness.